The presentation we have for you today is entitled HIPAA 101, so we might as well roll right into our first slide. Because we're an oversight body, we always have to start with a disclaimer. We can't give what we call an advanced ruling, which means, we're here to help you understand how the acts work, that we provide oversight, but at the end of the day, we can't prejudge any situation, so we can't give you the thumbs up or the thumbs down. We have to ultimately, when a complaint comes through the door, sit back, assess it on its merits, take a look at what law applies in the specific fact circumstances, and then the commissioner will have formal findings and recommendations that come out in a public report. So what we provide in a presentation and as advice over the phone is what we call non-binding general summary advice. And when it comes to the reports that the commissioner has issued, those are available publicly on our website. So if you're interested, please take a look at those, the investigation reports and review reports. However, if there are details within those reviews or investigations that aren't within those reports, we are unable to speak to any further details because, of course, they were confidential processes. The next slide is just a quick overview in terms of what Sherry and I are going to take you through today, and you can read for yourself. There's quite a bit. We're quite ambitious in the short time period. There is a lot to know about this statute, which you'll see has been in force since 2003. And what HIPAA does is it strives to balance two things. We're talking about individuals' rights and conversely the obligations, the duties on trustees in order to protect the personal health information. So the rights are about the individual and the duties are about the organization. And when we look at what specifically those rights and obligations are, we have to dive deeply into HIPAA. So when does HIPAA apply? There are three elements, and we hear often people will talk about trustees and that they believe they're a trustee. But at the end of the day, if there isn't also personal health information as defined by HIPAA, and that trustee has what we call custody or control, which I'll define in a minute, HIPAA does not apply. And HIPAA is just the acronym we use for the Health Information Protection Act because, again, long-titled law. The definition of personal health information is on the slide, and it's quite broad. What you'll see is it can be any of the above and combinations of the above. So for instance, information about the physical or mental health, about the health services that have been or are presently being received, information about organ or bodily tissue donations. This one's interesting, information collected in the course of providing a health service, and it could be incidental, but if it ends up on the patient record, even if you may not normally consider it personal health information, it can get lumped in to that definition as well. And lastly, registration information, which unfortunately there's not a clear comprehensive definition of what is registration information in the Act, but it's the basic information that you need in order to process a patient and move it through billing and other of those consistent uses of the information through the system. And the health services number gets lumped into that section as well, even though there is another section of the Act, Section 11, that speaks specifically to it. So then talking a little bit more about who can be a trustee, and the list is actually quite broad, and it's in the definition section of HIPAA under 2T. And so our starting point when we get a complaint in the door is to take a look, does this organization actually seem to fit in one of those definitions? And sometimes the clause will point to another law. So we have to go and take a look to see, oh, well, is this organization maybe an affiliate or a healthcare organization as defined by another act like the Regional Health Services Act? So it takes a little bit of legwork on our part. And then in terms of custody and control, the Act uses the custody or control, not and. Custody, you think of physical possession. You could actually go to your computer systems, you could go to your paper files. The information should be at your fingertips. It's within your offices, it's readily accessible. But the thing about custody is that at the end of the day, you still have to have a measure of control, which means that if there's information that was provided to you, maybe unsolicited, and it has nothing to do with the business that you're in, then maybe you shouldn't have it. And it shouldn't be in your custody, and it should be returned or destroyed. Control is the right to manage. So you could have employees or contractors that have the information off premises, for instance, but because you have the right to control that information, you have the right to tell them that it must be produced, for instance, if there was an access to information request. So we put those all together, and guess what? The prize is HIPAA applies. So now let's take it down to your level. When we look at HIPAA, well, you guys should qualify as a trustee pursuant to 2T, Roman numeral 7, as an operator defined in the Ambulance Act, which of course it's up on the screen. 2D, ambulance service, means a service held out as available for the conveyance and stabilization of patients, and includes the dispatching of ambulances, but does not include air ambulance services. And then clause K, operator means a person who is licensed pursuant to section 32 to operate an ambulance service. So that's kind of our starting point. And what we're not discussing in this presentation today is if federal law called the Personal Information Protection and Electronic Documents Act may have application. We call it PIPEDA for short. It's actually a law that the Privacy Commissioner of Canada is responsible, and it does have some application in Saskatchewan to those organizations that are engaged in commercial activities. But that is, you know, a talk for another day, or a referral to the Privacy Commissioner of Canada's office. The next thing I think is really important, now that we looked at the specifics and we know HIPAA should be operable in the circumstances, what are some of the key concepts that underlie access and privacy laws, including HIPAA? These concepts, I think, are important to get a grasp of too, because we hear people use them almost interchangeable when in fact they do mean different things. So I'll start with privacy. What's interesting about the term privacy is that when you look at these privacy laws, privacy is not defined. What is defined are terms like personal information or personal health information. And with HIPAA, it's only personal health information, not personal information. So the second you start dealing with, let's say, an employee's performance, that's not going to be captured by HIPAA. That would be potentially captured by PIPEDA if it has any application. And sometimes trustees are also local authorities or government institutions, and there would be a different law that might apply in those circumstances, but not to get too complicated. So in terms of privacy, there's a lot of different dimensions of privacy. It's generally known as the right to be let or left alone. When I think of privacy too, I think specifically of it, the context in the work that we do, and it's one specific dimension, which is information or data privacy. So it's about the individual's right to make decisions about what happens with their personal health information, and having some right to say yes or no to what happens to it. But with these laws, what they actually do is they enable trustee organizations in order to use someone's personal health information, sometimes without their consent, because it keeps the wheels turning in terms of the ability to provide health services. And we'll talk about consent in a little bit. So then what's the difference between privacy and confidentiality? Well, in order to have personal health information protected, you need to make sure that you're keeping it confidential and only sharing it with those that need it in order to do their jobs. And we'll talk about need to know in a second. It's the duty that's placed on individuals to keep that information as secret as possible, or to the extent they can with their jobs and their other obligations. But at the end of the day, if the individual, the patient, doesn't trust somebody, then they're not going to share the information, and there is no confidentiality. So it really is important that individuals, patients, they have trust that their personal health information is ultimately going to be protected. And that's where security comes into play. Security is just one way in which we protect that personal health information. In our world, we talk a little bit more about safeguards, which are controls. And we have a number of slides where we specifically get into some examples of safeguards coming up shortly. So in HIPAA, there are 3 types or forms of consent that are contemplated. The highest standard, we're talking about the ceiling, the gold standard, is express consent, which can be verbal or in writing. And if you think about it, it's the opt-in. And the individual has to have knowledge. It is revocable. And the individual can decide yes, but tomorrow no. And in terms of the electronic health record, there is even masking that's being built in, so that at the end of the day, if an individual doesn't want certain healthcare professionals to have access to their information, they can actually provide this healthcare directive, and it must be respected, even though it could be overridden. Then there's applied consent, which is the next step down. And we usually think of that as the opt-out, where you say, no, I don't want to participate in it. But by my actions, if I have been informed in terms of what's going to happen with my personal health information, you can infer from my actions that it's okay for the information to be collected, used, and disclosed. The floor is deemed or no consent because I can't revoke it, where I can with an implied or an express. I can say no, and my wishes need to be respected. But with deemed or no consent, the individual doesn't have a say in terms of what happens to that personal health information. And you'll see in HIPAA that there are circumstances when that is the case. When we look at the rest of Canada in terms of pan-Canadian-wide, in terms of what the consent standard is, it's an implied consent model, because at the end of the day, it's giving individuals the information they need in order to make an educated decision as to yes or no if they want their health information to be used in a certain fashion. But HIPAA was written with all three. So what we encourage trustees to do is to look at a particular situation and to make a judgment and say, even though the law may allow me to rely on a deemed or no consent, can't I move to a higher form of consent in the circumstances? In a circumstance in which you would not be able to rely on a higher form of consent is if you have an unconscious patient. So I think that's an obvious example. And another thing I think is really important is to be clear that when we're talking about consent in HIPAA, we're not talking about consent for treatment. We're talking about consent for the movement of personal health information throughout the system. So two of the fundamental principles that you'll find in any access and privacy law is the need-to-know principle and the data minimization principle. And what the need-to-know principle is that trustees and their staff, and that includes your contractors, volunteers, anybody that comes in contact with personal health information, should only collect, use, and disclose that information needed for diagnosis, treatment, or care of the individual. And the broader provision is for arranging, assessing, providing, continuing, supporting diagnosis, treatment, and care, and anything that's a consistent use. And Sherry will talk about that a little bit more. So you look at a person's job description, and what is it that they need to know in that moment in order to do their job and to do it well. So it's very episodic. You know, you may think, I have this patient this minute, but I may not have that patient the next minute. So where does my need to know begin and where does it end? What you'll see is we don't promote circle of care, which is not found in the Act, because it almost sets up this static group of individuals that always have a need to know, rather than, depending upon the individual and their needs, you may need to bring different healthcare professionals in to a different extent on different days. And if it's nice to know, you're just curious, then guess what? You might have a privacy breach on your hand. So it's really important to ensure that all individuals within your organization that come into contact with personal health information understand this concept. And the second that works hand in glove is the data minimization principle. So it's not only that you have to need to know that information at the time, but it's the least amount of personal health information at that time period. So if you only need to know 6 things about the patient, if a 7th detail is provided, that too could be considered a privacy breach. So it's only collecting and bringing in that information that you need to do the job necessary. An example of a field that is in some of the old legacy systems that there really wasn't a healthcare need for was religion. And so there's been discussions we've had with some health regions over the years in terms of, well, what are you doing to ensure that you're not necessarily collecting religion for every patient, especially if it's something that the patient isn't asking for, and maybe it's not an end of life situation. So it's looking at what you're collecting and bringing in and thinking and asking the question, do we need this? Is this something that really is part of the need to know? Sherry.
So I'm going to start talking about the collection of personal health information. The general rule is trustees must only collect PHI if it is reasonably necessary to provide a health service. in a case of an ambulance, first responder, you're collecting certain details of personal health information in order to provide diagnosis, treatment, or care. A secondary purpose would be listed in sections 27 through 29 of HIPAA, and these are the secondary purposes are things that are not related to diagnosis, treatment, or care. Collecting personal information directly from the individual to which it relates is the best, but there are of course exceptions. If the individual is unable to provide the personal health information, which could very likely be the case if at the scene you're dealing with an unconscious patient. If the individual could prejudice information, if there's family history issues. So always a general rule, direct collection is best, but sometimes it's not always the best way to get the information. A trustee can use personal health information with consent. Again, reasons listed are in sections 27 through 29. Trustee can also use PHI in order to de-identify personal health information. And picking up again, they cannot use PHI for employment purposes without consent. Again, it's all around consent. The first bullet, it's a general theme. So in terms of disclosure, you can disclose PHI with the consent of the individual. Can also disclose PHI for arranging, assessing, providing, continuing, or supporting the provision of a service required by the individual. So it relates back to the, diagnosis, treatment, and care. There's many more reasons that are outlined in sections 27 through 29 of disclosure of personal health information. This would be without consent. This includes to minimize a danger to health and safety for the purpose of settling an estate, court orders or subpoenas, in some cases to the Minister of Health. HIPAA, there's many reasons. You would have to go through those sections to see if a particular reason would apply. This is definitely a non-exhaustive list. Something I am sure your employees deal with a lot is disclosure of PHI to police. So it's important to note that police and RCMP are not trustees. If you're disclosing to the police or the RCMP, you need to consider the authority to disclose because it would be a secondary purpose that's not related to the diagnosis, treatment, or care of the individual. It's very important to establish internal policies and procedures so that your personnel understands it. This is where training becomes really crucial for your employees. There are also some portions of HIPAA in the regulations of disclosure to the police. So section 5.1 in the HIPAA regulations outlines disclosures to police. So a trustee may disclose to the police if the PHI is requested to enforce or carry out a lawful investigation under the Criminal Code or the Canadian Controlled Drugs and Substances Act. If you're disclosing for this purpose, it's limited to registration information and the nature and severity of an injury that was suffered by the subject individual, and it's connected to the enforcement or lawful investigation. The second piece outlined in the regulations, also in section 5.1, is the trustee may disclose to the police if the individual received or was offered health services directly as a result of an incident that is subject of a lawful investigation under the Criminal Code or the Controlled Drug and Substances Act. If you are disclosing for this purpose, it's limited to the factual circumstances surrounding the incident, the factual services surrounding the provision of or offered to provide health services, and the factual circumstances do not include the health history of the individual before the incident occurred. Another provision that's common in all privacy laws would be the disclosure to avoid harm. That's found under subsection 27(4)(a) of HIPAA. Now, there's certain criteria in order for you to make the decision if the disclosure to prevent harm is allowable. There has to be a real expectation, a reasonable expectation of harm. It can't be trying to connect dots and think they may, like, you can't come up with a bunch of hypothetical situations. There actually has to be a reasonable exception of harm. Harm must constitute damage or detriment and not just inconvenience. And must be a connection between disclosure and the anticipated harm. So this is another area where I think it's really important to develop policies and procedures and train your employees on, because they deal in a lot of high stressful situations where they're going to have a lot of people coming to them for information. So it's really important that they understand policies so that they can make these decisions.
And just lastly on that point, health regions have actually come up and developed forms so that when they are approached by the police, they are going through the request systemically and making sure that it's not just a fishing expedition, it is actually tied back to some sort of a lawful investigation, and that at the end of the day the trustee is only disclosing the limited information as listed in the regulations. Because the regs list specific elements, the trustee cannot go broader than that and provide additional detail, unless, of course, they were relying on some other provision like 27.4a, as Sherry mentioned. The other thing to remind you is when it comes to disclosure, for the most part, it's discretionary. Even in terms of a warrant order or subpoena, sometimes those can be challenged, for instance, if the name is wrong. And the other thing is, there is provision in HIPAA that allows for disclosures if another law authorizes it. So sometimes you have to do your research. But at the end of the day, if someone's asking you for the information and you're not comfortable that you have the authority to disclose, you can always say no, because it could result in a privacy breach if there isn't solid, support behind it, either through consent or through legal authority to provide that disclosure. So duty to collect accurate information. Clearly, with personal health information, if you don't have accurate information, people could die. There are lots of safety issues, but it's also in terms of an individual's right. It's not just to access their information, but it's also to make sure that there aren't inaccuracies, errors, or omissions within the information. So what we've provided here is some steps that can be taken to verify the accuracy of the information. And sometimes there's professional codes and ethics and things, bylaws that you have to adhere to as well, which will stipulate specifically things that you have to do when it comes to record keeping. But here are some suggestions from us. Another thing to keep in mind is, Sherry pointed out, the police are not a trustee. That doesn't mean that information can't be shared if the organization or the individual is not a trustee. HIPAA allows for that free flow of information, even to non-trustees, if it is, that need to know, if it is the continuation of that diagnosis, treatment, or care. And a perfect example is we have a lot of organizations in Saskatchewan that just because of their makeup, they may or may not constitute a trustee under HIPAA, even though they're in the business of providing health services. And HIPAA will authorize the sharing of that information, but it just makes the individual jump through some additional steps. But if it is a trustee, then the same obligations come to that second trustee that the first one had. So if I am trustee A and I share personal health information with trustee B, it becomes part of the records of trustee B as well, and going forward they have all of the obligations under HIPAA the same way that I do. And this is where I jumped ahead a little bit in terms of disclosing to people or organizations other than trustees. So some other considerations. In HIPAA, there are specific sections that speak to information management service providers. These are others that you contract with, that you enter into agreement, and they're providing things like IM, information management, or IT, information technology services. They're processing, storing, archiving personal health information on your behalf. But at the end of the day, you have to make sure there are formal written agreements that make sure that you keep control over that personal health information. There are also provisions in HIPAA that talk about a comprehensive health record. eHealth Saskatchewan is kind of at the heart of that right now, and we don't have time to get into the EHR viewer, but it's one of the ways in which a lot of personal health information from data repositories and other sources is being brought together so that the healthcare professionals can access that information all in one place. And continuing duties of trustees speaks to what happens if, for instance, a trustee retires, dies, moves on. You know, their responsibilities for the safeguarding of that personal health information, making it available to patients, doesn't end just because they decided to quit. Information management service providers. These are some of the elements that should be going into these types of agreements. We actually have resources on our website that provide all of these elements, and we don't have time to go through them today, but as you can see, there's quite a few specific components that need to be in these agreements to ensure that at the end of the day, the trustee retains control of that information throughout its life cycle, from providing the IMSP with the information to the termination of the agreement, and what happens in between to make sure that the IMSP is following the rules, which is retention and disposition. You know, how do you make sure that the information is not only retrievable and readable, but at the end of the day, how long do you keep it? And with HIPAA, the specific provision that speaks to record retention and how long it should be kept is not yet proclaimed. And so instead, it's looking at what kind of record retention schedules do you have based upon your needs of your organization. But at the end of the day, if you destroy it, it must be destroyed in a secure manner. A secure manner is not burning it in a barrel. We've seen too many cases where the flames are put out and the information isn't fully burned, and then it is blowing in the wind after the fact. Duty to protect. These are the safeguards, and it's taken right out of HIPAA Section 16. A trustee must establish policies and procedures to maintain physical, technical, and administrative safeguards to assure all of the following. And some of those safeguards, well, let's break them down. The first are the administrative or the operational safeguards. And when you think about it, it's the things that the organization puts place at a higher level to make sure there's going to be a consistent approach across the board. And things like access restrictions are really important. If you think about the healthcare professionals that have specific job descriptions within your organization, and you have a shared drive, can every employee get access to all the information on that shared drive? If so, it could be a privacy breach. You have to look at a specific role and what information do they have a need to access, and starting from that point on in terms of the specific job. And then if the individual, for instance, goes on a leave or they're terminated, is that access revoked? Did they have remote access? If so, that should have been terminated at that same time. And you can see there's a lot of other examples that are listed there. Technical, I think those are the obvious ones. If you think about the technology that we use, primarily computers, what do you have to make sure that individuals are authenticated when they're accessing these systems? A simple thing that should be done is every time one employee logs on and they walk away from their system, is they're locking out that workstation, so another individual can't walk up and access what information the other individual was seeing. We've seen a lot of privacy breaches as a result of that. And lastly, physical safeguards, I think those are obvious as well. Do you lock your doors? Do you have a clean desk policy? I think often we're worried about what happens during office hours, but what's happening afterwards in terms of the cleaning staff when they come in? You know, what are they able to see when they walk in that front door?
So we've talked about collection, use, disclosure, consent, safeguards. When there's a failure to comply with all of this that we've talked about so far, that's when a privacy breach will occur. It can be simple as not having an alarm system, somebody breaks in and steals stuff. You can, not have the appropriate consent to disclose. There's many, many reasons where a privacy breach can occur. Our office, and you can look, I have an example that we can talk about a bit later, but there seems to be a new type of privacy breach that we're seeing a lot of is employee snooping. We do have reports on our website that deal with employee snooping. So an employee can access PHI and they do so without a legitimate need to know. They might just be curious, bored, or they actually want to harm an individual. It's really, really important to have policies and training specifically to employee snooping. So investigating privacy breaches. Our office has a resource that is very, very helpful. We'll take you through the steps to appropriately investigate a privacy breach. It's Privacy Breach Guidelines for Trustees. It's available on our website. So despite best efforts, privacy breaches do occur. Our office outlines 5 high-level steps that you should be taking in order to respond, including containing the breach, notifying individuals, including the affected individuals, our office, regulatory bodies, law enforcement if appropriate, investigating the breach, taking steps to mitigate risks to prevent future breaches, and then preparing a privacy breach report. So now that we've done the privacy, we're going to touch quickly on the right of access. HIPAA provides individuals with the right to access their personal health information in the custody or control of a trustee. They have a right to access their own PHI. Having that right to access their own PHI is different from a trustee using or disclosing the PHI. So you might think access is about you accessing it within your office. But in this circumstance, it's actually about an individual coming to you and say, I want access to the report that occurred on this date of this incident. It's accessing their own PHI. The right of access is spelled out in HIPAA. So an individual can make either a written or oral request for their PHI. It must be in the custody or under the control of the trustee. They must give sufficient detail so you can identify the record. And you have the right to ask the individual to prove their identity before granting the access to their PHI. A trustee has 30 days to respond to an access request. They may have additional 30 days in some circumstances, and a trustee may charge fees. We always say look at the consistency of the fees allowed for in the Freedom of Information and Protection of Privacy regulations. But our office resource IPC Guide to HIPAA can provide you further guidance on fees. If you're not the appropriate trustee, so perhaps it's not you that has the PHI being requested, it was the hospital that has that, you can transfer the request to another trustee. In terms of right of access, HIPAA actually imposes an explicit duty on trustees to assist individuals, and it's outlined in section 35. So you shall respond to a written request openly, accurately, and completely. And also, if an applicant requests, a trustee shall explain codes, medical terms, abbreviations, or find someone who can actually provide the explanation. There are limited circumstances where a trustee can refuse access, and they are found in section 38. Endanger mental or physical health or safety, would reveal PHI of another individual without consent, would identify a third party who's supplied the PHI, will be used in investigation or judicial proceeding. It also allows you to sever or redact portions of the information. So if an individual requests access to that information and there is an error and they can provide sufficient proof that there is an error, they have the right to request an amendment. As a trustee, if you receive a request for amendment, it must be in writing, and you either make the correction if there's a sufficient evidence, or add a notation that a correction was requested, and that should include what the amendment was actually requested, the date it was requested, sort of details of that right of amendment. So we are an independent office of the Ledge Assembly. The Commissioner has oversight for FOIP, which is Freedom of Information Protection and Privacy Act, LA FOIP, which is the Local Authority Freedom of Information and Protection of Privacy Act, and HIPAA. We have a mandate that includes informing members of the public of their information rights, resolving access and privacy disputes, making recommendations on appeals from access to information decisions by public body, investigating and resolving privacy complaints, issuing recommendations on public bodies, policies and practices, and commenting on proposed laws and policies affecting access and privacy rights. The privacy powers under HIPAA are outlined in section 52. I've covered a lot of that already. In addition, we can recommend a trustee take the following actions done in contravention with HIPAA. So cease or modify a specified practice of collecting, using, or disclosing information, or destroying collections of PHI. We can comment on collections of PHI in manner other than directly from the individual, privacy investigations as covered already, and comment on implications for the protection of PHI of any aspect of the collection, storage, use, or transfer. So in terms of the privacy breach investigations, we encourage complainants to try and resolve frustrations with the trustee first. We ask for complaints in writing. We will ask the trustee for an internal investigation report, and what we look for is based upon our privacy breach guidelines we'll give you what we're looking for. So if you go through that document, we may issue a public investigation report, which is available on our website. It wouldn't name the complainant, but it would name the trustee. We make additional recommendations, and we may refer offenses to the Attorney General if necessary to see if further legal action needs to be taken. And similar with requests for reviews, we review access decisions. So we review decisions to refuse access. We review decisions regarding an amendment. We have recommendation powers, and we, again, can issue a public review report. So kind of that final slide on how to be HIPAA compliant, the big takeaway: have a privacy officer, provide extensive training to staff on HIPAA requirements and provisions, have comprehensive, clear, practical written policies and procedures that are reinforced through leadership and training, have written contracts with IMSPs, audit of use and disclosures of the personal health information, and effective enforcement action to follow any breach. We've listed some resources that we've spoken about today. Also, the Saskatchewan College of Paramedics, which I believe would be the regulatory body. And with that, follow us on Twitter.
Thank you all for your patience.
Thank you.